As part of any divorce proceeding in New York State, when there are minor children, part of that filing is a request that custody be determined by the court. So that's part of any divorce. We can still resolve it, even though we've asked up front for the court to resolve it. And generally, we are able to resolve it without the court's assistance, but it is part of the initial request, part of that initial filing. In New York, if you go to a hearing or a trial to determine custody, to ask a judge to make that determination for you, those trials are generally very lengthy. Most of the time, an attorney will be appointed to represent your child. We call that the attorney for the child, the AFC. Many times, courts will also appoint a mental health professional, a forensic psychologist or psychologist, to do an evaluation, to speak to whoever it is appropriate for them to speak to, whether it's the parents, of course, the children, whether it's the teachers, whatever caregivers may also exist. And they'll be giving a report to assist the court in making that determination. When we do these hearings, both parties will testify, and there are times even that the children will testify, often in what's known as an in-camera interview with the judge outside of not in open court. So in New York, when there is custody litigation, generally the courts will appoint an attorney to represent the child, an AFC, an attorney for the child. As a general rule, their role is to represent what the child wants. So if the child is old enough to express a desire to live with one parent or the other, or whatever it may be, that is that attorney's role, to represent your child. In custody cases, when there's allegations regarding abuse or neglect, that's something that a court will, of course, be very interested in hearing. They're going to listen very carefully to that. Those are situations where it's critically important that the attorneys are well-versed in those areas, sensitive to the issues surrounding that, so that whichever party they're representing, they can put on the strongest case possible. There are circumstances where grandparents may feel the need to petition the court for custody or visitation, or what we call access to the children. It's tragically something that is not uncommon when one parent is deceased or is not available, whether it's because of a drug or an alcohol problem. Those types of cases where either the grandparents are seeking custody or visitation, or there is a parent who is defending against that, that is something that we do with some degree of frequency these days. There are occasions where we'll be consulted by a party who claims that the other side has violated the custody or the visitation order. Those are situations, depending on how egregious those violations are, that may require a return to court. The court has power over that agreement or over the decision that was previously made, as long as the children are minor. So until that time, until they age out, a court will hear that, and they'll have the power to modify custody, to change it, to take away custody, switch custody from one party to the other, and certainly to modify the access schedule if it turns out that it's not working out, that one party refuses to abide by it or is unable to abide by it.